Good morning, everybody. My name is Komal Agarwal, and today I am presenting my topic on the public international law. And my topic is concerned with the international law of the Unilateral Declaration of the Independence and respect of Kosovo, and the advisory opinion which is given by the ICJ in 2010. So, firstly, let's start from the background of this particular case. Uh, Unilateral Declaration of Independence and respect of Kosovo. The background is in 2008, Kosovo Declaration of Independence was adopted on 17 February 2008 in a meeting of the Assembly of Kosovo. Then it was the second declaration by the Kosovo. The very first declaration was made in the year 1990, date 7 September. Serbia decided to seek international validation and support for its stance that the declaration of independence was illegal at the International Court of Justice. So, whether the declaration was in fact an official act of the provincial institution of self government was unclear. In the end, the court determined it was issued by the representative of the people of Kosovo, acting outside the normal provisional institution of self government. This was significant since the Serbian argument was that the Kosovo Provisional Institution of Self Government had exceeded the authority given to them by the constitutional framework promulgated by the United Nations Mission in Kosovo. So, this was exactly background. It is only concerned with the legality of the declaration made by Kosovo at the international level. So, UN requested to the ICJ for its advisory opinion in the General Assembly at its 22nd meeting held on 8th October 2008, adopted Resolution 63 by 3 entitled and requested for an advisory opinion of the International Court of Justice on whether the unilateral declaration of independence of Kosovo is in accordance with the international law. In this resolution, the General Assembly decided in accordance with Article 96 of the Charter of the United Nations to request the International Court of Justice, pursuant to Article 65 of the Statute of the Court, to render an advisory opinion on the following question. And the question is very much clear: is the unilateral declaration of independence by the Provisional Institution of Self Government of Kosovo is in accordance with the international law or not? So, in the public hearing which is made at the International Court of Justice, Kosovo and Serbia both had presented their case. So, firstly, I would like to discuss the points which is raised by the Serbia in the International Court of Justice. Serbia said Kosovo's unilateral declaration of independence violates the foundation of international law. It is a challenge to the authority of the United Nations and a challenge to international legal order based on the principle of sovereignty and territorial integrity. The declaration represents an attempt to abolish the UN administration in Kosovo, to annul Serbia's sovereignty over its southern province, and to impose independence as a unilateral solution for Kosovo. The independence proclamation was made by the temporary Kosovo government and was in violation of UN Resolution 1244, which guarantees the Federal Republic of Yugoslavia's territorial integrity. Now, the points raised by the Kosovo's independence is reversible. This will remain the case not only for Kosovo but also for the sake of regional peace and security. After violating the human rights of Kosovo's Albanians, Serbia had lost its right to the country. The will of the people of Kosovo to freely determine their political status goes back many years and was clear to all participants in the 1999 Ramblit Conference. It was clear immediately after the 1990 conflict. The negotiation for the final status of Kosovo were supposed to convince Serbia to recognize its independence. So basically, this was the points raised by both the countries, Serbia and Kosovo. Now, advisory opinion which is given by ICJ has divided into five parts. The very first part is jurisdiction and discretion, and then scope and meaning of the question, factual background, the question whether the declaration of independence is in accordance with international law, and in last, general conclusion. The very first is jurisdiction and discretion. In this, court notes that in the present case, the question put by the General Assembly asks whether the declaration of independence to which it refers is in accordance with international law. A question which expressly asks the court whether or not a particular action is compatible with international law certainly appears to be a legal question. It also observes that in the present case, it has not been asked to give an opinion on whether the Declaration of Independence is in accordance with the rule of domestic law or not. Whether then court respond to this question by reference to international law without the need to inquire into any kind of domestic law. Court therefore considers that it has jurisdiction to give an advisory opinion in response to the request made by the General Assembly. There are no compelling reasons for the court to decline to exercise its jurisdiction in respect of the request before it. So, court accepted the jurisdiction, and the second one is the scope and meaning of question. Here, the court observes that the question posed by the General Assembly is clearly formulated. The question is narrow and specific. It asks for the court's opinion on whether or not the Declaration of Independence is in accordance with international law. It notes that the question does not ask about the legal consequences of that declaration. In particular, it does not ask whether or not Kosovo has achieved statehood, nor does it ask about the validity or legal effect of the recognition of Kosovo by those states which have recognized it as an independent state. The court accordingly sees no reason to reformulate the scope of the question. So, there was no chance of skipping the meaning of that particular question. Now, the factual background of this case, as we are already aware about the factual background, we discussed earlier about it. So basically, it was the question related to the declaration of independence by Kosovo. So no need to repeat it again. Then we will move further about the question whether the declaration of independence is in accordance with international law. So the court first notes that during the 18th, 19th, and early 20th century, there were numerous instances of declaration of independence, often strenuously opposed by the state from which independence was being declared. Sometimes a declaration resulted in the creation of a new state. Other side, it did not. In no case, however, does the practice of state as a whole suggest that the act of promulgating the declaration was regarded as contrary to international law. On the contrary, state practice during this period points clearly to the conclusion in international law contain no prohibition of declaration of independence. Please, I repeat, no prohibition of declaration of independence. During the second half of the 20th century, the international law of self determination developed in such a way as to create a right to independence for the people of non self governing territories and people subject to alliance subjugation, domination, and exploitation. Then, court further observed that the illegality attached to the Declaration of Independence just stem not from the unilateral character of this declaration as such, but from the fact that they were or would have been connected with the unlawful use of force or other egregious violation of norms of general international law. In particular, those of a preemptory character, just cogence. The court notes that in the context of Kosovo, the Security Council has never taken this position. Then court considered that it is not necessary in the present case to resolve the question whether outside the context of non-self-governing territories and people subject to alliance subjugation, domination and exploitation, the international law of self-determination confers upon part of the population of an existing state a right to separate from that state, or whether international law provides for a right of remedial succession, and if so, in what circumstances. After that, it recalls that the General Assembly has requested the court opinion only on whether or not the Declaration of Independence is in accordance with the international law. The court notes that debates regarding the extent of the right of self determination and the existence of any right of remedial succession, however, concern the right to separate from a state. That issue is beyond the scope of the question posed by the General Assembly. To answer that question, the court need only determine whether Declaration of Independence violated either general international law or the lex specialis created by the Security Council Resolution 1244. The court further considers that general international law contains no applicable prohibition of declaration of independence. Accordingly, it concludes that the Declaration of Independence of 17 February 2008, which is made by the Kosovo, did not violate any kind of general international law. Uh, in last, court concludes that the court accordingly finds that Security Council Resolution 1244 did not bar the authors of the Declaration of 17 February 2008 from issuing a declaration of independence from the Republic of Serbia. Hence, the Declaration of Independence did not violate Security Council Resolution 1244. The court thereby concluded that the adoption of the Declaration of Independence of 17 February 2008 did not violate general international law, Security Council Resolution 1244 of the constitutional framework. Finally, it concludes that consequently the adoption of that declaration did not violate any applicable rule of international law. So this was my presentation, and I hope you will like it. So thank you so much. My roll number is 220661. So thank you so much.